What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
And welcome back to the Zona Law podcast. I'm Mark Zinman. We got a fresh face for you to the podcast. Welcome, Teran Porter.
Thank you. Good to be here.
Many of you guys have been working with Zona for years. Will recognize Teran from court, but this is the first time he's here on the podcast, so we'll see how he does. Hopefully the comments won't be too tough on you.
Right.
I know you guys were thinking, how can they have another podcast? Well, it's the law. There's always things to discuss, and today it's going to be security deposits. I think this is something from whether you're a new manager or an old manager, it's kind of a topic you have to cover, and there's hopefully something that we can address and you'll learn from today. Before we jump into the actual legal side of stuff, though, let's get to know Teran. Let's play Who is Mr. Porter? So, Teran, what can you tell us about yourself? Family, kids, dogs, what's the life outside of the practice?
Yeah, so outside of Zona Law Group, got married this last year.
Congratulations.
Thank you. So, yeah, I'm married to wife Mackenzie, and then we have two beautiful little dogs, not kids.
He was very close to saying kids. He may have slipped up there by accident. All right, sounds good. So what were you doing before Zona Law? Is this your first job?
So I've been with the firm for 2 years now. It's flown by, but before joining Zona, I was with a large international corporation doing government contracts. So pretty exciting stuff.
I was going to say, there's a big jump from government contracts over to the landlord-tenant world. Right. So I got to ask the question. So whether it's Zona, whether it's the work, what is it that you like about where you are? Hopefully you do like it.
Yeah, no, love it. So, I mean, that's the main difference between the contracts day-to-day was the same. Here with Zona, each day is different. Love working with our clients. Hearing your stories, each one is different. So I love communicating with you guys.
Yeah, I don't think managers realize, like, those random crazy issues you may run into, like, once every 5 years. We see those emails every single day, and it's just amazing, which makes our jobs, I like working with our managers, just like you said, and going through those kind of crazy stuff. So one of those things that we see all the time from clients, like we're talking about, is security deposit accounting issues. It is by far the number one lawsuit that residents file against landlords. What's the main reason for that?
The main reason is the upside from the tenant's perspective. There's little effort for them to bring that suit, and they can get up to 3 times the amount wrongfully withheld in damages.
Yeah, excellent. Right on point. It's that 3 times what's wrongfully withheld. And we're going to go to the details that, again, people kind of forget that it's always just 3 times or what it means. We'll go into that. But let's start at the beginning. So obviously it has to do with deposits, the amount you take up front. And it seems like an odd question of what is even a deposit, because you have deposits, you have fees, refundable, non-refundable. There is a definition in the Act, and it means security is money or property given to assure payment or performance under a rental agreement. Security does not include a reasonable charge for redecorating or cleaning. So those redecorating and cleaning, I would think of those as fees. Are those refundable or non-refundable?
So that's important to make the designation in the lease agreement. So they can be refundable or non-refundable. You want to make that distinction in the lease specifically. If it's not designated, that's going to be a refundable fee to the tenant.
Yeah, automatically. So if you don't specify it's non-refundable, automatically it is. I mean, generally our suggestion is when you're breaking down those things, I know people like to have like a pet deposit, a cleaning deposit, and then a security deposit. I mean, generally we suggest try and bundle all those to just one deposit, which is refundable. And then if you have those other things like a cleaning fee or a pet fee, then that would be in addition as well. And that's not included in the cap. So what is the cap for security deposits?
So according to the statute, a security deposit can't exceed 1.5 times the monthly rent.
Okay. And so what happens then with source of income with Section 8? Let's say the rent is $1,200 or $1,000, and the tenant's only paying $100 of the $1,000. What can you charge the tenant for on that deposit?
You can charge the whole amount. So you have no obligation to reduce your security deposit. That's something that they're still going to have to come up with.
Yeah, and I think that's important for people to realize. Like, if the rent's $1,000, your deposit's going to go up to $1,500. It doesn't matter the tenant's only paying $100. They're still liable, and they have to come forth with that full $1,500 to show and obviously to protect you guys in the event that tenant damages the property. So generally, that's how we try and break it down in terms of fees, which we like to see as non-refundable, and then the deposits, which just put together and cap it out. So where the lawsuits come from, what the statute says, which is basically, everyone remembers, you have 14 business days to get your accounting done. And the question is, done from what? Where do you start? What's day one? So what are the elements really that we start there?
So back to the statute, there's basically 3 elements that the tenant must meet before you send that accounting out. So after the termination of the tenancy is one, delivery of possession is the second one, and the final would be a demand from the resident for the security deposit accounting.
Yeah, which is amazing because that's in the law, like you mentioned, but nobody realizes that it's actually a 3-prong analysis for each one of those: the demand from the tenant, termination, and the return of possession. Now, as a practical basis, we always suggest clients just say, whenever you get possession back, so when you get possession, that's when you should start. So if the tenant turns in keys to you, or if the constable executes the writ, or you complete the abandonment process, the day you get keys back, that's day 0, and the next day is day 1. That's the easiest, cleanest way to do it. But it is interesting the statute has all 3 of those as a requirement. So you start those. Day 1 is the day after you get possession back. It's business days, which means what?
So you're not counting the weekends and you're not counting legal holidays. So court days, business days, that's your requirement.
So then we're saying you have these 14 business days, which usually takes about 2.5 or 3 weeks, the time you have, to get the accounting or the check out. What happens, though, if you don't have all the damages or you don't know all of the numbers within the 14 days? Do you still have to do anything?
Right. So if you know you can't make the 14 days, you still have the requirement under the statute. So it's important to at least estimate the damages, send that first accounting out within the 14 business days, and then you can follow up and send another one once you can assess all the damages.
Yeah, and to me, that's perfect, where you send the accounting within 14 days and then the final one later if you have to. Because to me, if you end up in a lawsuit, you're showing the judge, hey, I knew what the statute is, I met what the statute did, and I went above and beyond, and this is the final amount that actually is owed by the resident. So let's say, okay, you're ready to send this out, and we'll go in a second to how you actually calculate the stuff. But let's say you're ready to send it out. How do you send that, and where do you send this accounting and potentially the check?
So how it's sent out, this is the one portion of the law where you can send out via first-class mail. There's no requirement like other legal notices that need to be sent by certified mail. However, we would make additional recommendations to you as well.
Yeah, and so it's funny, and we probably blame ourselves as the attorneys. We hammer to clients that notice in the Landlord-Tenant Act is hand delivery or certified mail. Hand delivery, certified mail. I can't tell you in the 17, 18 years I've been doing this how many times I've said that. But for your deposit accounting, it actually says first-class mail. And the reason goes years back, if you sent something certified to the tenant, it wouldn't be able to forward. Well, obviously, if you're sending it to the last known address, which is maybe the property, it was thought it wouldn't get to them. So the law is written such that it has to be first-class mail, and hopefully it'll track them. But what else do we suggest in addition to what the law says?
You could reach out by email. I mean, that's a huge way of communication nowadays. Oftentimes, that's how you're communicating with them, normal day to day. So doing the additional email communication will, again, show the judge that you're going above and beyond.
Yeah, and that's what we love to do is like hit the legal requirement, but also go to what practically is the best method. And so the law doesn't address email, but it's a good way to go so they actually get that notification as well. Okay, so let's go to the actual accounting itself and what you do. Let's say you've got, really comes to 2 situations where a tenant moves out 6 months into the lease, has 6 months left, or they fulfill their lease, and then there are other still charges. And the way we kind of break it down is financial stuff and physical charges as well. So what are the financial charges?
So going into financial, you're looking at rent and other monetary charges such as, like we said, the rent, utilities, HOA fees. That would be your financial charges.
Yeah. And then what about the physical? What kind of damage things, what do we see?
Correct. So physical, you're talking damage to the unit. You're talking holes in the wall, other,
pet stains.
Right.
I'm trying to think. We've probably seen it all.
Yeah.
We laugh because the clients send us these pictures, and I'm like, how does somebody living in there? I mean, you think about somebody that was hoarding and the amount of damage that it can do, or if somebody was smoking in a unit, inside, it can literally turn the white walls yellow. I mean, it's disgusting. You can't even imagine the things that you see. All of those fall under that physical category. And in those cases, what you're doing is you're charging for the cost to put it back the way it was. So if it needs a air freshener or if you need a deep cleaning, all of those costs you charge against the resident. But there is some buffer for reasonable wear and tear. So what is that? It's the catch-all, right? The tenant's liable for damage to the unit except for reasonable wear and tear. So what's your concept of what reasonable wear and tear means?
Right. So reasonable wear and tear is, the normal use of the apartment. So you're not going to charge for things that have a certain lifespan, such as carpet and paint. Like we said, you have a reasonable lifespan of 5 to 7 years on those. So that's the time period you have to take into account when you're going to charge for those. Specific things.
I think the way judges look at it, that's the cost of doing business. I mean, it's expected over a life of an apartment, certain repairs have to be made. And like there's a certain amount of damage that a tenant is allowed to make just by living in the property. They're going to do some wear and tear on the carpet. Well, if you think about what Taran's saying is that carpet or paint could be a 5 to 7 year lifespan. That means every 5 to 7 years, the landlord has to replace that carpet. So let's say a tenant's you install new carpet. Tenant's there for 2 years, fine, no problem. Next tenant's there for 2 more years, and then when they move out, you have to replace the carpet because they damaged it that bad, maybe their pet, maybe something else. So you got 4 good years out of that carpet, but you didn't get the 5th year because that's how long that carpet was supposed to survive. So at that point, that last tenant only wasted your one last year. So 1 year out of 5, that's 20%. Whatever the cost of replacement is, you just charge the resident the 20% of the replacement cost. But we've seen a ton of cases where maybe it's 10 years, and then the landlord charges the last tenant the cost of replacement. That's not correct, right?
Right. I think the distinction goes with paint too. When you're talking about if they're putting, hanging up pictures and they have holes in the wall, you're not going to charge them for a full house full of paint. You're charging for what you use. Yeah.
Exactly. And same with appliances. It's just important that it's not the last person that suddenly picks up the bill for all the past work that's been done or how long the appliance has been there or the carpet or the paint. They're just liable for whatever loss they caused beyond that normal wear and tear, beyond the cost of doing business. And that's what people have to stay to. And so that happens pretty much with all damage to the property, right?
Right, yeah. So no matter what you're dealing with, like you said, Mark, carpet, paint, appliances, holes in the walls.
Holes in the walls they're liable for, though, right?
Correct, yeah. So you're just talking reasonable wear and tear.
Correct, exactly. Now, if we switch back to the financial side, the financials is they failed to pay, they failed to fulfill the different obligations. Like Teran mentioned, obviously rent, fines, fees, maybe even utilities, HOA bills, all of those things that can apply that just really come dollars and cents. You charge them for the full amount of what they owe. So if it's in the case, though, certain cases, depending on the term of your lease, you'd have to see, is there a lease break if they don't fulfill their lease? Or if there's no lease break, they're liable until the property is re-rented or until the end of the lease, whichever one comes earlier. And so it could be if somebody skips out 6 months early in that initial accounting, what you're talking about, you're going to say, hey, you're liable for the next 6 months. And you send that out within the 14 days. But maybe 2 months later, you get it re-rented. And so you send out that final accounting saying, hey, we got it re-rented. You're only liable for the 2 months. And again, that goes back. You show the judge, hey, we got within what the law says, and we went above and beyond that as well. Now, let's turn to the lawsuit itself. So the tenant files this lawsuit. What burden is on the tenant?
So like we said at the beginning of the podcast, there's little downside to bringing the lawsuit from a tenant's perspective and a lot of upside. When the tenant brings a lawsuit, they just have to claim that you've wrongfully withheld, and the burden shifts from the tenant to the landlord to prove all the damages that you've charged.
Yeah. And so the biggest risk a tenant has if they file this type of lawsuit when they don't get their deposit back is the landlord either counterclaims saying, hey, you actually owe me so much more, or even if the landlord's not counterclaiming, they're just going to seek their attorney's fees against the tenant. So the risk downside is that they lose and get a judgment against themselves.
Right.
The upside is that they potentially prove that something was wrongfully withheld. But what Taran's mentioning there, what's interesting is the tenant's filing the lawsuit, but the whole burden shifts to the landlord. So what does the landlord have to prove, Taran?
They have to prove that these damages that they've charged were beyond reasonable wear and tear. They're going to need 3 things to help prove that case. Those three things being pictures and video. Ideally, the pictures would be from before the unit was rented, and then definitely after, showing the damages. The second thing would be invoices for what you paid to re-rent the unit. And then the final one would be the security deposit accounting, and that you timely sent that.
We like to make things simple, right? Rule of three is just it's an easy way to memorize everything. But really, I mean, this point in time, everybody has a cell phone. There's no reason you should not have pictures and or video. It's just that simple. And if you think about it from a judge's perspective, if a judge looks at your deposit accounting and it says $400 for cleaning, they're not likely to challenge that if they can understand. If they see pictures of a hoarding situation or they see pictures of so much garbage filled in, $400 to them, they're going to be like, yeah, we'll grant that. But if they just see a charge of $400 for cleaning, they're going to be like, well, maybe that's unreasonable. A picture is worth 1,000 words. We cannot stress that enough, and it's such an easy box to check, there's no reason to. And so you come in with the three things Taran's talking about, which is your pictures and videos, the actual invoices you get from your vendors, even if you're using staff, for example, a reasonable amount for that, and then, of course, making sure the accounting is setting out timely.
And piggybacking off that, the pictures aren't enough. The pictures need to support the invoice. So taking a picture and charging an unreasonable amount, like Mark said, the picture has to show what you've charged in the invoice.
Yeah, and I don't think it's real. I think there's such a narrative people try and push out there. Landlords are out just trying to steal security deposit accounting and steal the deposits. We don't see that. I mean, our clients are very conservative in terms of what they're charging and actually just putting them back to the way they were. But with that narrative, that's what the judges hear all the time. So you have to be on point for what you're charging and having the documentation. Now, you mentioned earlier, this is what we're going to wrap up here with here as well, something about 3 times the amount for what's wrongfully withheld. What are we talking about?
Right. So if you have a security deposit for $1,000 and you withhold $500, and a judge sees that the $500 you withheld was actually wrongfully withheld, the tenant is you're liable for 3 times the $500. So you could be on the hook for $1,500.
Which is amazing if you think about it, because the deposit was only $1,000. You only deducted $500, but if for some reason the judge found that it was all properly charged, you may end up at $1,500, which is more than the deposit to begin with. That's why it's so important you have the documentation. And most judges don't really dispute the charges on the reasonableness if you have the invoice, if you have the pictures. But if you just missed sending something out, that's a problem. Now, the flip side of that as well, if the tenant burns down the property, I don't think you need to refund anything. And I don't think the 14 days is as big of an issue. I don't think it's wrongfully withheld, even if you miss the 14 days. But again, there's no reason. You take the 14 days from getting possession, and it puts you back, and at least it protects you as to what the law says. And as lawyers, look, it makes us feel better. do what the law says, please. It's Taran's first podcast. Just make the man happy. Do what the law says. But with that, hopefully you're generous to Taran in the comments. We appreciate you seeing here. And until next time, we'll see you on the Zona Law podcast. And do you want to say like and subscribe?
Please like and subscribe.
Who doesn't say that for a legal podcast? Take care.